This is now being recorded, so stop saying all the ridiculous stuff you were saying, guys.
No, it's just easier for me to say.
Let's go.
Oh, congrats to the teams for making it to Octos finals of the illustrious Stanford Octa tournament. Your panel is Zoe.
Keith.
If you could just refer to us as esteemed panel or honorable panel, that would be awesome. Or just panel, I guess.
Cool. Hi guys. Great to meet you guys. Thanks to Miriam for averaging a 38 at this tournament. This has been fun. Everybody ready? At the point in time when one of the most famous American artists, Elvis Presley, took literally all of his songs from a black artist whose name I can't even remember for the purposes of this round, I think it's pretty clear that we need to talk about this issue some more. We're going to model this pretty simply. We think it can be, basically Western liberal democracies. We're fine with it applying elsewhere to the way it applies. We think, basically, we're going to prosecute this as a crime. Exactly what kind of crime? Obviously, we're not putting somebody in jail for life. We think it's reasonable to assume that there will be degrees based on exactly the amount of copyright infringement. We also think this is not just Elvis, but it's also people putting stuff online for like LimeWire in 2017, whatever that is. Any questions?
Yeah. Okay. Cool. Hold on for a second, because this actually does change the round significantly. So the interpretation of the Gov is that we would criminally prosecute copyright infringement. So like if white artists violate, or if white artists copy minority artists' work, then we prosecute white artists, right?
Yep.
I see. Gotcha. Okay. Cool.
And also online stuff. We think it applies to both.
Wait, sorry, what do you mean by online stuff?
Like if I am running a website where I go out and rip artists like CDs and put them on the internet for like free download rather than like for sale. Also copyright.
So like SoundCloud and stuff?
SoundCloud is generally like you put your own music on there as an artist. Like SoundCloud is pretty protective. I'm talking about like when you like put something up for illegal download. Like illegal consumption.
So you're like basically it would be like a minority artist puts up something that people have to pay for. Someone legally samples it or uses it in another distributory mechanism. And
I think a bit like an actual big issue is illegal downloading of like albums and stuff. So like what is it's not just LimeWire, but there are a ton of websites where you can rip albums. Like 3 copies of.
And how are you defining minority? I guess.
So I think this varies a little bit from nation to nation. We're going to talk probably most about like historically oppressed minorities within the state, but like we can find your basic like minority group that has a sub 30% amount of population. I think this applies most in states where there's like one massive population that is the majority and multiple other. Like I don't think it's situations where there's like 5 different ethnic groups and they all make up 20%. Like that's.
Yeah.
So one big question about how the state determines which cases to pursue in your side of the house, is it that like the state has a method of like getting complaints by minority artists and then like independently investigates them, or?
We're fine. Look, so in any criminal case, right, somebody can bring a criminal complaint, but also we think the state should just be investigating this and
like actively, right? Like even if the minority artists don't want the suit to happen.
Well, so that's different than if the minority artists don't know that their copyright was infringed upon, right? So like. If the minority artist doesn't want the suit to happen, they can give somebody permission to use their copyrighted stuff. So that's presumably not like if I have a copyright for something and I give permission. Okay,
sure, yeah.
So I don't think that applies.
And I guess what are you? Maybe this was already answered, and I'm just being it out. But what are you counting as copyright infringement?
So
like anything from
I'll give you the broad definition. I think sampling that is illegally done would be like potentially a copyright infringement. I think there are scales to this, right? So like, look, you can sample something, and as long as you give credits and stuff, it's not copyright infringement. And as long as you're not using it for profit, like if you just put a sample of something on YouTube, like that's not potentially copyright infringement. We think probably the bigger stuff is like sampling that isn't credited or stealing of beats, obviously putting whole albums online for illegal download.
And this also probably applies to art too.
Yeah, Also paintings and shit and sculptures.
Sure.
I couldn't think of a good example.
Final question, I promise. What's the status quo?
So status quo is you can sue. Whatever. I feel like you just kind of know it's wrong, but I'll make this easier. Status quo is you can sue in civil court in most countries.
All right. Cool. Good.
Yeah. Where was I? Let's talk briefly about the principle. Look, we think governments have constitutions to protect minority groups and their rights. We think minority groups are the worst off and they face unique harm, so government has an obligation to try to help them most for 3 specific reasons. First, we think this is where they get the most efficacy, the most bang for your buck, we say, because this is where the most harm is being done. But second of all, we think they face unique types of harms that are uniquely damaging in terms of erasure of cultural identity and other things like that. We think the government has an obligation to try to prevent those harms specifically. But lastly, they face historical injustices. Minority copyrights are just one of many rights that have not been enforced historically to protect minorities or have not been applied to minorities historically. But they are one important one. I think Elvis is a critical example of this. We think to rectify this harm and the harms it has led to in terms of respect for black artists and other minority artists, we think it's important that the government try to prosecute these, try to help minority artists as much as possible. Second point. Let's talk about status quo, because status quo really sucks, and it sucks that they have to do it. Look, we think when you have to sue for profits, this is incredibly bad for a couple of reasons. First, I already told you, you may not know that your copyright has been infringed upon. Why? Because if you're an artist, it's actually kind of a difficult thing to be searching the web and seeing which websites have your album up illegally, etc. Or which famous song sampled your lyrics or your line, etc. This is why sometimes 20 years later we see suits finally coming to pass at a time when it's really difficult to prove any sort of copyright infringement, any sort of mens rea, etc. But secondly, we think the resources to skew are huge here. Look, minorities in societies generally tend to be worse off. That means they probably have the lesser resources. They need top-notch lawyers in order to prove copyright infringement because it's an incredibly technical thing. They're often going to be suing people who are incredibly well off, especially majority artists who have the protections of a big firm, etc. Which means the resources you need to sue are critical here, because you can get hung up in a court case for years on end. The other side can just try to bleed you dry. At the point in time where you have the government doing the investigative work for you, that makes it way easier. But secondly, I think this police investigation is critical. Look, when you're just a random artist, you don't have the resources to go out there and find who is running this website that is putting your stuff up illegally, or who is the one putting it on that website, who is the person ultimately profiting off of your work that is not you. We think that is incredibly difficult to do, and it requires the sort of unique resources police have. Subpoena power to get search warrants, power to pull phone records and IP address. I don't really know the tech. There's a lot of stuff there that police can do that civil courts cannot do. We think that is critically important insofar as you literally have nobody to sue if you cannot figure out who is stealing your stuff. But the third thing is credibility. Look, insofar as there is a skew to this point because of historical copyright infringement that has not been copyright laws that have not been enforced, it is going to be more difficult for minority groups to claim that a majority group took their work. This is also because of biased juries, which we think we've just empirically shown juries are way less likely to believe minorities. But the fourth thing is that people can hide profits, right? We think this is just another way of something, of a way for a majority group to use their resource advantage to protect themselves against copyright lawsuits. And lastly, oftentimes minorities are not signed to the biggest firms in the Hollywood business, the people with the expertise to get this done, while majority artists are. So when a majority artist rips from a minority artist, they have a big firm protecting them that's been doing this forever and has a ton of credibility, etc., in the industry and in the mind of the public. On our side, the minority artist, however, is totally screwed. Is probably trying to fund this lawsuit themselves. We think credit is critical here. I want to impact this. Look, it is not just the profits, but it is the credit for the work that gets produced that is so important. Why is this the case? We think respect for cultures is deeply important. We base a lot of this off of art. When you hear sort of racially tinged rhetoric from Trump supporters, it's often things like, but what have minority groups produced? It's we have this, that, we brought jazz in. They credit themselves with literally everything. At the point in time when minority artists aren't getting credit for things, it means that they're going to be a lot less respected in school. But also, it leads to whitewashing the industry, because when there's less respect for minority artists, it's harder for minorities to get jobs in the industry on end. But lastly, awards are frequently based on sales, and it is a show of respect. It is how artists get famous and move up the line. Insofar as awards are based on sales, and minority groups that are not represented by a big firm that knows how to prevent your stuff from getting ripped off the internet are likely to be harmed here because it's their work that is most likely to be put online to be illegally downloaded, which means their sale numbers are going to be disproportionately unfairly low because it's not taking into account this online stuff, which means minority artists can't win awards and therefore get the respect they deserve. Third independent point, economics. Look, at this point, art is functionally a public good. We think this is actually problematic. It's access without payment. Everybody can get it online, especially minority artists who don't have these big firms to protect them. But there's no payment coming to these minority artists. They're basically producing this work with no real way of accessing any sort of monetary benefit. So when there's no payment, there's no resources with which to produce more art. But there also is no incentive to try to continue producing art. Insofar as you're not making a lot of money doing it, we think at some point you're probably going to give up and move on to a job that allows you to pay the bills better. We think this is critical. We think also the other options for funding that exist, other than like direct sales, and this applies specifically to the fine art world, are bad, especially for minority artists. Why? Because it's generally private grants set up by old white men who made fortunes and were like, yeah, why not? I'll put $1 billion in the trust to fund some art. We think the type of art that they set up, for example, the National Foundation for the Arts even says, or the National Endowment for the Arts even says, we want morally pure work. It's literally in their charter. We think, insofar as the biases that exist within our society tend to be to think that the majority culture's version of morality is the version of morality that's most correct, what likely happens then is it is harder for minority artists to get access to these sorts of funding for any sort of art. Lastly, we think there's an incentive to keep your art private or put it up in an incredibly high paywall, behind an incredibly high paywall. Beyonce is probably going to sell her album at $20 rather than $10 because she has way fewer people buying it. And the only people who buy it are people with enough money to care about the quality of the download they're getting, which means she has to make it incredibly expensive. On our side of the house, we think that means it actually discludes minorities from accessing that work to at least some degree. We also think that trying to keep art private sort of defeats the purpose of art intrinsically. But the impacts here I want to get to are cultural. Look, we think, on balance, all the arguments I just gave you about how we're not going to get enough minority art, this is critical for two reasons. One is within culture. It is critical for unity and self-love and the idea that your struggle is joined by other struggles, by other people who are similarly struggling, and that your struggle is beautiful. We think that's incredibly important. But lastly, there's the pain of your art being stolen when you love your community and you see your community putting out beautiful pieces of art, when that art is taken from you and somebody takes credit for it. It is incredibly hurtful. We think that's a problem. But lastly, outside, look, we think art is incredibly effective political messaging. It shows people the harms that a community is undergoing in an emotive way. It can bring people's emotions to understand past historical injustices and injustices in SQUO. That is an incredible, effective political tool we lose on their side of the house. Proud of you.
To thank the Prime Minister and call upon the Leader of Opposition. Here we go.
Everyone good? So the first argument I want to advance is that copyright law should never be prosecuted criminally, because what we heard in the last speech was a lot of reasons about why minority artists might be impacted a lot under the status quo and about Elvis and things like that. But they never gave us a legal reason as to why this intellectual property should uniquely fall under the purview of criminal law as opposed to civil law. So here's what we're going to advance under this point. Two notions as to why this should never be prosecuted, actually three notions as to why this shouldn't be prosecuted criminally. So the first is that we think the distinction between a criminal case and a civil case is based on a violation of a fundamental right that is enshrined within the law. This is why we don't go against intellectual property in the status quo criminally, because we think that there's a difference between harming someone's property by accidentally having a tree fall on their lawn, which can be sued civilly, and intentionally doing something with the harm of robbing someone. We think that robbing someone carries a unique psychological harm with it that is difficult to distinguish. Now, they might try to come up here and say, well, IP protection is basically like robbing someone. You're basically trying to steal the fruits of their labor, and that's necessarily bad. But first of all, we tell you that the way that it's defined usually is without necessarily harm to the person, because we think that intellectual property doesn't carry those same psychological problems that it otherwise would necessarily do. But second of all, we think that a lot of this intellectual property can be sued under these really weird things. So the difference, I think, between why this is not criminal is that you're not necessarily taking anything away from someone. They still have that property under their name. But you are harming the economic potential of that property. There's a difference between violating the property wholesale and taking away some economic advantage of it, and I think that distinction is what the economic courts try to compensate for, i.e. the civil courts. But the second argument under this is just the question of desert. So I think it's quite clear that we don't always think about crimes as necessarily a violation of law necessitating a criminal prosecution. We also think about whether or not the punishment should fit the crime. So what we would say is that 3 or 4 years in jail should probably not be assigned to something as simple as simply sampling someone's song without their permission. We think that that should be reserved for crimes of a higher order, which we think are necessarily more important to protect against. But the final argument we would advance under this point is just a question of the harm principle, because this ties into a little bit of the earlier analysis, but essentially what we think is that it's difficult to show a clear harm that is non-economic in damage when it comes to taking intellectual property or using it in a certain way. And so we think the only way to actually compensate for this correctly is through the civil case. The second argument that we would advance, though, is that this won't succeed in any sort of criminal court. So a lot of the arguments that they give on their side of the house are actually flowing to our side of the house because they're basically it's difficult to establish mens rea in a lot of these cases. The criminal court is very ill-equipped to deal with a lot of these things, and there's a 99% bar of proof that you have to prove in order to demonstrate that your property has actually been violated. So what happens on their side of the house is that, yes, maybe some criminal prosecutions get brought forward, but then they have to show beyond a shadow of a reasonable doubt that their intellectual property was being sampled for 15 seconds, actually violates the economic damages. First of all, a lot of the criminal court is not equipped to deal with these things. So when they talk about, weird technologies that they have, recognize that these technologies are used for, policing and figuring out mens rea in the actual world, not on the internet world, where you don't have that same sort of judge presence. But further, we would just argue that owing to this higher standard, we think it's super unlikely that you're ever going to win a case. So where does this become an impact? Because admittedly, at this point, it just seems terminally defensive to say that they'll never win a case. There are 3 impacts we think that happen when you allow these lawsuits to go forward, but you don't necessarily have any sort of chance of winning. So first of all, we think that resources are fungible in the criminal court. And so the weighing analysis we would do is that if this means at the expense of investigating something like a robbery or a murder, the state is actively prosecuting instances of things like intellectual property violation, we think that that is a massive waste of the state's time and resources. The second impact we would argue, and I'll take you when I get to on case, is that there's sort of a backlash against this protection. Because a lot of their analysis is basically look, these minority artists are not recognized in the mainstream as having any cultural contributions. The problem is on their side of the house, on both sides of the house, they get some sort of credit, either through the civil or criminal system. The difference, though, is that those same Trump supporters that they've just described are now able to be look, black people have a leg up in our criminal system, and they still don't have, this sphere of art. They need this special protection for their art because they really can't produce anything worthwhile. I think this actually entrenches the perspectives on their side that are incredibly biased against black artists and minority artists in the first place. But finally, we would argue that you're less likely to trust the system when you keep failing in the criminal courts. Because recognize that a lot of the time, the minority artists that they're talking about really only have the option to do things like represent themselves criminally or civilly. What we mean by this is that if you choose to represent yourself criminally, you think that you might get a higher amount of proof on them, you might get that person in jail, so you might pursue that alternative instead of pursuing someone civilly, because you have to pay lawyer fees presumably for both. What this means, therefore, is that a lot of the minority artists on their side of the house will pursue the criminal system for justice as opposed to the civil system. This robs them of their ability to actually get justice because whereas they have a 50% burden of proof perhaps in the civil system, they think, oh, we'll just get the criminal system and we can get an easy win there because we'll be provided a lawyer, things like that. However, when they start losing these things, they're less likely to trust the system in the future, which we think makes a chilling effect on people producing art in the future. So final argument I would give under this is that it's probably bad for the government to determine what types of art are worthwhile. Look, a lot of the times it's not going to be the case that the government is actively going to prosecute the minority artists that they want. The minority artists who publish albums for some sort of small price but aren't attached to a record label. Because here's the thing. The only people who are probably going to be able to get the state's notice are the ones who are already under some level of record label. It's incredibly difficult for an independent artist to come forward and prove mens rea on these cases, but record labels tend to have the financial resources to get the state's notice, have lawyers, make the state think that they actually have a prosecutable case against another company. What this means is that the people who are most impacted or most hurt by the system, the independent minority artists, will never get protected. But those minority artists who are under record labels would probably already be able to sue under the civil system, since the record label has an interest in protecting their intellectual property. So we think that they would be fine no matter what. But you would disagree.
So when I take Beyonce's album, I put it on the internet, I make money off ad revenue, and I give it to the world for free, how hard is it to prove that I was trying to steal her copyrighted work?
Yeah, so the point is that if that were the case, if someone were stupid enough to do that, Beyonce's massive record label, Rockefeller, would already come after them in a civil case. The problem is, though, if they think that there's going to be a criminal case as well, they have to establish a 99% burden of proof. I think it's actually a lot harder to do that. And furthermore, there needs to be a distinction between why stealing Beyonce's album, putting it on the internet, and then selling it is different than stealing Adele's album, putting it on the internet, and then selling that as well, which we haven't seen from the legal fiction that you guys have created. So going to their case, the first argument they say is that minorities are the worst off for 3 reasons. They say that they're the most affected, there's an erasure of cultural identity, and their laws haven't been enforced historically. What we would argue, however, is that this doesn't meet the standard for making something criminally prosecutable, which they have to explain in their next speech, why this should actually meet the burden of a criminal prosecution as opposed to normal intellectual property law. Then they say that the status quo is that you sue for profits because it's hard to search for a lot of these things on the internet. So recognize that the clear-cut cases will be very clear-cut and people won't do them because record labels will go against a lot of these things already through the civil system. The question, therefore, is should you give record labels a leg up by giving them the option to criminally prosecute as well at the expense of independent artists who don't have access really to either system? They say that people have other tools. So the police have other tools. I think I already addressed this. A lot of these are ill-equipped for the system. They say that juries don't believe people. This is going to happen in both the civil or criminal case. But the difference is that criminally, the juries really won't believe people, and then you have to prove it beyond a shadow of a reasonable doubt, so nothing will ever happen. They say that they just need credit for work, but they never explain why the criminal system is the only way to get credit. Why putting someone else in jail for sampling your song is the only way to get credit for that work. They say that minority artists can't win awards. Look, the people who are actually getting ripped off are not the ones who are likely to win awards in the first place. The award winners are probably protected under record labels already. They say that people have no incentive to make art. I think you have less of an incentive to make art when there's a chilling effect worrying that the government will actively suppress your art because it might be criminally prosecutable. For all these reasons, so proud to Octos.
It's ludicrous to say that we never have criminal trials when the only harms are economic, because there's all sorts of financial crimes for which most of the harms are economic, and we still have a criminal trial. So what's a more reasonable standard here? We're going to say, first of all, it's worth having a criminal trial when you think the civil system is not going to solve for the large harms which are happening to people. In this case, we think the civil system will necessarily not solve because there are huge externalities. What do I mean by this? Basically, when minority artists are systematically excluded from getting credit for their work, minorities as a whole suffer because there's a view that they're not producing valuable things and they're not contributing to society. It actually increases racism and leads to all sorts of major harms for everyone in society. The problem is, under the civil system, only the minority artist actually has to sue, right? So they're the person who's bringing the lawsuit, taking on all the burden, taking on all the cost of the lawsuit, even though the benefits of winning the lawsuit shouldn't only flow to them. Therefore, we think the state has an interest in intervening here and using criminal trials as an additional tool because there's all sorts of other people who are suffering who won't be solved for under the current civil system. But also, we just think it's ludicrous to say you don't have a property right to your intellectual property. Their argument here is robbing has a unique psychological harm, and also that you're not taking something away because you can still access your music. But here's the problem with this. We think it definitely does have a psychological harm when someone steals your music. In fact, a more intense psychological harm because it feels like you're not getting credit for something that is kind of integral to your being. Like, the art which you produce is basically an expression of yourself. It's a very, very deep and personal thing, and to steal it is therefore deep and personal as well. But also, we think this argument that just because you're not taking something away, you're just taking away an economic advantage, and therefore it shouldn't be criminally prosecuted, is nonsense. Because this distinction would mean that if someone does property damage to you, but you can still use the property, then you shouldn't have any sort of prosecution. But obviously, when someone does some sort of property damage to you and therefore causes you economic harms, there also should be prosecution. Finally, they say that we're going to put people in jail for 3 to 4 years. Probably not only for the most severe crimes. In fact, a lot of criminal suits also end in fines. So I don't think that we have to defend the most unreasonable version of this statute. they also talk about how there are only economic harms. I just don't buy this. There aren't only economic harms to having someone steal your property and claim credit for it. We say that when you have a loss of credit for culture, you're actually viewed as less valuable as an individual, and therefore people overall tend to be more racist. There's broad societal impacts, which Nate talked about in his speech, and they never really dealt with in terms of like black people in America being systematically undervalued because their work isn't recognized. And this is worse in other countries. Like in a lot of countries, minority groups don't have as large of a role in like the music industry as black people do, and therefore even less empowered. So we tell you that this is harms for a broad swath of people, that these harms aren't just economic, and that this is clear damage. The purpose of setting laws is to prevent people from harming others. Even if that harm is just economic, this distinction makes no sense. Secondly, they say these cases won't succeed. First of all, we never said that you were going to need mens rea in criminal suits. Like, you can just prove that the person violated the law, and therefore, like, they should be prosecuted. There's not an intense statute here. But also, they say it's going to be difficult to win. Look, even if we only get a small number of cases that are able to successfully go through, we think we still win this round for a couple of reasons. First, the lawsuit in and of itself is damaging to the artist who chose to violate the law because there's a loss of reputation. There's a news story about how they chose to violate the law. There's actually a national conversation about these things which are happening. And in the status quo, when I, as like, say, a minority artist has to sue a majority artist, they don't have credibility. But when the state is bringing the criminal trial, they have unique credibility because they're the state, they're elected, they're just a much more credible actor than your average minority artist. The idea that there's going to be backlash from Trump supporters is actually non-unique because whenever minority artists have to bring suits on their own, there's also backlash from Trump supporters. The difference is we give these suits additional credibility because the state is bringing them. Also, we think even though there's a higher standard in criminal trials, the state is very likely to win a lot of these. The truth is that the state doesn't tend to bring cases that it doesn't think it has a chance of winning. So there's already going to be a filtering process. And if that means that in a lot of instances the state can't bring as many cases as we'd like, that's fine, because we still think the state is likely to win the cases that it does bring, especially because it has a large amount of resources that they can use that, like, your average minority artist who's trying to figure out if crime happened against them simply can't use. So we think you get more cases, and even if only a few cases go through, we think it's better. Also, they talk about how you're going to have fewer civil cases. This isn't how civil cases work, guys. First of all, like, people have an incentive to bring civil cases because they want their money back, right? So, like, it's not like you're only going to get a criminal case and then not a civil case. But also, we think that people will have a much easier time bringing civil cases now because, and this is just flat true, when you have a criminal prosecution happening against someone, and like that's happening even despite the higher standard of evidence, then judges and juries are more likely to believe you when you bring your civil case because it's like the state believes this, because it's almost as if the state is expressing its belief in you and therefore saying that you ought to be listened to in your civil case. So if you win a criminal trial, or even if the criminal trial is just brought, that actually makes it easier to bring a civil case and therefore allows minority artists to get more representation. They're also making a weird argument here that minority artists are going to bring criminal cases but then be more likely to lose those criminal cases. You can't both argue that minority artists are going to have an incentive to only bring the criminal cases and then also argue that they'd be more likely to lose those cases because they're going to bring the case they have the most likelihood of winning. This doesn't make sense. Their third argument is that it's bad for the government to say which art is worthwhile, etc. Look, we're not saying that like other art isn't worthwhile. We're saying that minority art has unique benefits to society that the government can recognize. First of all, because it tends to be historically undervalued, as Nate tells you, and therefore the government needs to correct for that, like the private market doesn't correct for that, and that's why the government has a role in intervening, but also because there's a comparative here. Like, it's easier for minority artists if the state is more aggressive in providing more protections for them. So, like, even if there's instances in which minority artists still won't get protections under this criminal system, the comparative is a more aggressive state allows you to get more protections. We also think, they say, what is the difference between someone stealing this and someone stealing Adele's art? Well, there is a difference, as we told you, because there's unique impacts to stealing minority artists' art. Like, when someone steals Adele's art, it's highly, highly unlikely that Adele, or much significantly less likely that Adele will end up not actually getting credit for her own work. It's significantly less likely that people will view white people as a whole as less valuable in society. And that's why it's more important to provide extra deterrence here, because it's more likely to happen, because minority artists, when their art is stolen, are less likely to be given credit. Then they say, juries will never believe you when you bring these cases. Like, look, if you have the state behind you, if you're providing good evidence, if you start getting a precedent of these cases winning, then then you're actually going to have juries be more likely to believe you, and then in turn that can trickle down to civil trials in terms of more credibility in civil trials as well. Let's move to the on case. The response to this, the response to the first point is that we need to prove that there are unique harms that justify using the criminal justice system. We say, saying that the criminal justice system has a high standard of evidence, it's okay for us to say, as long as the state can prove harms, therefore it should do a criminal trial. I don't think we need a much higher standard than this. But also, we think criminal trials feed into civil trials and help you win civil trials. They say that, and they have this big argument about how the people who win awards are going to be protected no matter what, and therefore we should care less about those people, and therefore we, like Beyonce will always have someone to bring a lawsuit on her behalf. Sure, Beyonce is likely to have someone to bring a lawsuit on her behalf, but the vast majority of other minority artists don't have someone to bring a lawsuit on their behalf, and having the state be more aggressive and defend them more is more likely to allow them to win things. Also, we think that there are people who are borderline, right, like who could potentially be winning awards at the Grammys but don't have the correct representation and therefore aren't able to do so. If we're able to get them credit for their art, this can have a trickle-down effect over generations where credit now leads to more credit later for minority artists in general. Then they talk about how this is going to have a chilling effect, potentially especially on minority speech. Look, given that they're arguing that these cases are still going to be fairly difficult to win, it's likely that in the majority of instances, unless you're doing fairly major crimes, then you're not going to be penalized. So we think it's fine to say that only the worst offenders will be punished, and that will therefore get no huge chilling effect. We're very proud to oppose.
I'd like to thank you, everyone, and call upon the witness opposition.
Okay, is everyone ready? I think it's clear that it's a necessary but insufficient burden for Gov to prove that, yes, criminal courts are uniquely able to, A, effectively punish these crimes, but then B, it is under the proper jurisdiction of criminal law in their side of the house. We think that it is an overextension of the carceral state to say that everything should be punished on a criminal level just because there are, quote from Miriam, harms to a wide swath of people. Why is that true? The first is that mens rea is important in a criminal court because it's an individual crime focused on individuals' intent to violate specific people's rights. On their side of the house, they would literally just say that anyone who's perpetuating a bad social norm or someone who's doing anything that's likely to spill over into the effects of minorities as a whole should also be punished criminally. That is obviously a slippery slope for the state to over-exercise its abuse of power over any type of crime because guess what? The historical disenfranchisement warrants they give in the MG are so generic to apply to anything you do against a minority person. For instance, anytime you violate a minority's rights, it does spill over to the state of representing black people as a whole because it is representative of some type of historical injustice. They need to show a proper bright line as to why intellectual property is somehow uniquely different. But the second argument is it's still comparative on the effects, right? Because all their arguments ultimately break down to the pragmatic effects of what happens to recognition. Like there's no inherent reason as to why you should prefer a desert claim on their side of the house because all their claims are criminal justice systems are more likely to give recognition to black artists. We say civil systems do the same thing. Why is that true? One is that if you win a civil court and if you win a criminal court, the ultimate result is the same. It is that people recognize through an official ruling that you produced the art yourself and not the other person. That means that there's no unique reason as to why a person has to go to jail or suffer a fine on their side of the house to actually get the proper punishment. But this is where Miriam also shoots herself in the foot. Because she's like, most of the time, people will only get a slap on the wrist in the criminal justice system. They won't actually get time in jail. This means that either, one, the punishment is so not severe, such that there's always an incentive for artists to rip off minority artists' work anyway, because they know they'll get away with a fine, i.e., none of the recognition benefits happen on their side of the house, because people know that they can get away with it. Or second, the punishment is so severe, such that juries are unwilling to prosecute the crime, because it's really hard, for example, when Elvis Presley is the defendant, and you're asking a group of 12 people who love his music to say, yeah, that guy definitely deserves to go to jail for producing an album I love. On their side of the house, either the punishment is so severe such that it ramps up how hard it is to prosecute under a criminal system, or it's so light that the civil system is obviously a better remedy, because at least the burden of proof is slightly better. But then they say, look, like on our side of the house, it means that we compensate for the intense psychological harm that is done by producing the amount of work. Intense psychological harm is not a criminal standard for putting someone in jail, right? Like that is the reason as to why objective physical crimes that are easier to prove in court are more likely to be codified under the criminal system, and things like emotional harm or emotional trauma can just have an additional effect effect on the economic compensation you get in a civil court. For instance, we are fine in our side of the house saying that in a civil court, if you can prove the spillover economic effect on psychological trauma and the psychological trauma of all your peoples, then you can just say, well, you should pay more in a civil court. That solves for all their benefits because, one, on a civil court in our side of the house, you also take into account that minorities were historically disenfranchised, meaning that minorities should be compensated more. But secondly, you get the same recognition because when a civil court says that you did produce this work, it's the same type of evidence that happened in the criminal system. I'll take you.
Yeah. So when you create psychological trauma for someone, that actually can be prosecuted in criminal courts. When you steal from someone, that can be prosecuted in criminal courts. So why is this not important enough to prosecute?
Our argument is the gravamen or the essence of the crime, even if psychological damage is present in a lot of criminal suits like assault or, for example, battery. It is not the reason as why the states are comfortable prosecuting it. That is, emotional damage is not sufficient for a criminal prosecution, even if in a lot of ways it is necessary. A lot of times what you need is some objectively provable state of mind or state of affairs such that you can prove that individuals suffered some type of real harm that is not unverifiable. For example, unquantifiable emotional trauma that they're just asserting on their side of the house. Ask yourself, what is sufficient evidence for psychological trauma? What is sufficient evidence for someone being more insulted or more hurt emotionally rather than physically? It's really hard to prove under a criminal system, which either feeds into our second infinite point, which is that it is impossible to win these cases because there's no such thing as reasonable evidence. That's why, for example, affirmative consent is so hard to prosecute in a criminal court. Or it is the case that there has been some physical damage done, in which case we're okay with using the criminal setting. The fact is, the civil setting is just so much better because of the proof and because of the variety of crimes that we can more adequately punish. Their next argument, though, is just that, look, lawsuits in and of themselves are a cost to people that you bring upon them because there's some type of reputational harm. One, the reputational harm is definitely temporary at best, right? There are suits all the time, for instance, that are high profile, that are happening in the civil court system that, sure, specific artists might have a little shittier reputation for, but they still do the same things they've done in the past because they know that the news coverage will blow over. But second of all, this doesn't happen in personal crimes either. For example, when Dr. Dre was criminally prosecuted, for example, beating someone or assaulting someone in a nightclub, people forgot about in the future because obviously artists don't care about the reputational harm the lawsuit brings. What matters is the ultimate verdict. So that is, all we have to prove is that they will almost never get the cases they want the most. In fact, here is the damning piece of offense. Because the types of cases they want to prosecute, the ones that the state is most likely to be most effectively garnering their resources for, are criminal prosecutions against minority artists who sample other minority artists' work. Why is that true? One is that minority artists are less likely to have the resources to have as much of a defense or as good of a defense as really well-known artists. That's impactful because the state will always go for the lowest hanging fruit. That is, in a world where there are fungible resources, where you can either choose to investigate a robbery or you can investigate IP protections, you're not going to investigate an IP law that you know you're not going to win against Adele or against Elvis Presley, right? You know that's a losing battle because not only have to prove it beyond a shadow of a reasonable doubt, but the nature of the evidence itself is so hard to grasp. That's what Miriam doesn't get because the resources, it doesn't matter how many state resources you have, if the data that you're trying to collect is inherently elusive, inherently hard to bring to a court, and incredibly difficult to represent in a favorable manner to avoid juries misinterpreting it, then they will lose the case 99% of the time. This is bad because when there is a high-profile case in the headline, like they say, or you know a court case is going on, after 2 years, if the artist loses the court case, then it sends a signal that harms the recognition of all minority artists, right? The fact that you're losing a high-profile court case against someone who is most likely to violate your IP rights means that you're doing them a disservice on their side of the house. On our side of the house, at least you never have the courts over and over again ruling on the side of the more powerful, more resourced people, and you also never have prosecutions of minority artists who sample other minorities' work, such that there's a better outcome on our side of the house. Look, the reality is, on their side of the house, they kill more minority artists because the only ones that will ever be successful are like Kanye, who are already under the protection of a record label, who already can produce a lot of the music that they would have produced otherwise. On their side of the house, the people who are most susceptible to sampling others' music, who are up and coming, the ones that they obviously care most about, the ones who are under-resourced, are not being helped. That fuels our third independent point, which is that only the people who can flag the state's attention are the people with powerful labels, right? The fact is, the benefits on their side of the house are almost non-unique and marginal at best, because the only cases that they're going to win, the high-profile victories, so they say, are artists, for example, on the par of Adele, artists who are just as famous, like Chance, after he won a Grammy, like Kanye, like people who already have the resources to say, look, state, you can aid me, you will most likely win the case, and not only that, you know for a fact that this will get attention. Then there's in the house, there's never an incentive for the state to pay attention to people they think they need to pay most attention to. And that is an incredible problem. So, let's go to the PMC. Miriam's unique argument here is that there are intergenerational impacts to credit, and that ultimately it spills over generations. But one, if you're more likely to win a civil suit, that is, if if you only have to prove a preponderance of evidence on our side of the house, it has the same generational effects, right? The fact is, if you prove on the criminal court, if you just win a bunch of criminal courts and you only have a slap on the wrist of a lot of artists who are violating the law, it sends no message from the rest of the house. It means that how much does the state care about violating your intellectual property? Like a $500 fine. That's not an effective message on either side of the house. Moreover, when they say that it's not mutually exclusive and you just go through a civil court afterwards, the problem is that A, artists are less likely to believe they can win a suit when there's already been tremendous evidence gathered against them as well, because the defense has already been really invested in defending the person who's defended in the criminal complaint, right? The evidence, insofar as it is really difficult to demonstrate in either side of the house, it is better never to delegitimize their claim, never to go into a system where your reputation will definitely be harmed, where you will definitely be looked at with skepticism by the public, and instead go the route that you know will benefit you instead.
Is everyone ready? Let's start off by giving them their best case scenario. Let's say the only thing we care about is the people who are most impacted, and that's who we should protect. Then our argument was this. We said that the only people who the state is going to actively prosecute on behalf of are the ones where they think that they have enough evidence, where they think that they actually might win the case. They admit that it's going to be very difficult to win these cases beyond a shadow of a reasonable doubt. So our argument was this. They are only going to pay attention to artists who are already protected by record labels. This is for two reasons that really went unresponded to. First is the idea that the state will only pay attention to those who they think have a winning case. That is, people who have teams of lawyers who have prepared legal evidence that the state can then use, and then use it to prosecute someone else. So the people that we think who are going to actually have winning suits are people protected under record labels. Why is this so bad? Because we told you the additional warning in LOC that went dropped in the MG speech, that minority art tends to go on more minority art. So a good example of this is if Kanye releases a mixtape, and then someone else, an independent artist, uses a beat from that mixtape, the record label, Rockefeller, is going to sue on behalf of Kanye against the minority artist, the independent artist, who would otherwise be able to profit from that money. So the people who are worse off are the people who are the most economically disenfranchised. The one who won't win because they don't have a record label, they don't have a team of lawyers, they don't have access to the legal system. We are the only people helping them because all they do is give another avenue for record labels to pursue justice against independent artists who they think might be ripping them off. So we win cleanly under that issue. Let's say you don't buy that then. What do they say next? They say that there are some unique benefits. So let's give them an even better case scenario where some minority artists actually get recognition through this criminal court. What we tell you is, first of all, that there isn't any additional benefit to the message of going through a criminal court. Rather, we gave you the argument that there tends to be backlash when you create a separate legal fiction for a minority characteristic of artists, because this pursues the belief that people think that minority artists are less deserving or have less cultural contributions, and the state needs to intervene in order to protect them. The argument about the awards and Grammy stuff still doesn't matter a lot because we gave you the argument that, again, independent artists are not going to be the ones winning these trials. What did we tell you that I think went fundamentally mishandled? The weighing analysis is this. If you try the criminal prosecution than the civil prosecution, you are less likely to go forward with the second step after you've lost the first step. The state has already presented a mountain of evidence as to why you might have won and you still lost that case, which means that you're less likely to pursue civil recompense even if they get their best case scenario. What this means for them is that they don't actually get any sort of damages awarded to independent artists who would otherwise be benefited. So, again, that's their best case scenario. The second question, though, is this deserving of the legal jurisdiction? And our weighing argument that I think didn't really get fundamentally touched in their speeches is the idea that legal jurisdiction ought to matter more than the respective harms that are caused to people, because the only way to ensure a fair and simple legal system is if you don't have unusual application of the law. When you give the government the power to selectively enforce law against different groups, you end up running roughshod over the entire system of law in the first place. So what did we say under this? I think they had some pretty good arguments, which is basically the psychological harm is not unique. You're still violating someone's property, so it seems like we should criminally prosecute it. But the reason why we don't, the reason why we put it in the civil trial is what Jim says is an MO, which is that when you have he said, she said trial, the state cannot prove beyond a reasonable shadow of a doubt, nor should it try to prove beyond a reasonable shadow of a doubt that some bad thing transpired. So on their side of the house, they have to explain why it's better to have a criminal trial where you're searching for an objective truth when you have this he said, she said case. But here's the other problem for them. Jim notes the double bind that they're in. Either the fines are so astronomically small that it's not actually that punitive and nobody ever goes forward with this criminal trial, at which point you have this whole other lever for people to use that never gets used, and then people think there's this enshrined area in the law that minorities could use to get recompense but don't, leading to less protections for them in the future. Or you actually have an unusual application of the law.
Wait, point of order.
Mhm.
Sorry, the argument that minorities will end up looking for, or there will end up being fewer protections for minorities legally because this protection exists, I believe is new.
Oh, it's not that substantively there are new protections. The argument is that because it's only a slap on the wrist, people believe that they're protected, but in reality they're not because it doesn't send the norm that you want to send.
Sure, I also think that's new.
No, that's not. I don't believe that that's new. So what he's saying right now is that the law won't be efficacious. But what he was just saying was both the law won't be efficacious and in the long run you will get fewer protections for minorities because there's a belief that protections for minorities already exist. That was said. That was not said.
I guess my response would be an LOC. I gave the argument that as a form of backlash against minorities, people think that they have special protections, which then leads to people believing there's false solvency for the problem. And I guess this might be like an example of that false solvency, but...
No, I totally buy you said that there will be backlash. I just don't buy that he extended it fully.
I think each member of the panel needs to take it seriously into consideration.
Thank you, Steve. The final thing they had to prove there is that there should be some sort of unusual application of the law, which is to say that they need to explain why a white artist who is struggling independently and getting ripped off is worth less than a black artist who is struggling and independently getting ripped off. The only thing that they have to offer under this analysis is basically like, there's some historical value to black art, which Jim explains is also intrinsic to a lot of different types of art, but that people don't believe them. If people don't believe them, then they won't be believed in criminal or civil trials, so a lot of this analysis is non-unique. For all these reasons, so proud to oppose.
Thank you, Leader of Opposition. Call on the Prime Minister to
Usual thank yous. Thank you. Esteemed, honorable, beautiful, wonderful. Okay. I'm going to crystallize a couple things for this, but I think one thing that's really critical when you do the weighing just off the top is that they give you not a path towards solvency for any of the 1.5 million status quo issues I lay out for you in PMC. And this is pretty critical because when we tell you that there are unique harms to minorities' ability to politically engage, to convince and speak to majority groups about their problems and about how these problems ought to be fixed, we tell you that the weighing is we get a 1% better chance of getting more art out there and convincing people more so of the validity of minority claims to oppression. You ought to fall to our side of the house because that is most important in this round. At the point in time when they don't even try to give you a path, like there isn't an argument on your flow for how this gets better in the long run, only stuff about how like our system would make it worse. I think it's pretty clear that if we get 1% efficacy, we're winning this round. So what do we think? What's critical here? They say the principle. They give you a couple of things. They say, first of all, it doesn't have the same psychological harm. So what we tell you is like, yes, you can prosecute crimes for psychological harms. Like emotional abuse is a crime. That's a psychological harm. Also, just saying a psychological harm is, quote, different doesn't mean it is lesser, especially when I explain to you in PMC why it is in fact greater. Therefore, we think, if anything, you have a bigger obligation to solve this, which we think is important. And then they say things like, but what about minority art is unique? Like, guys, that was all of PMC. Like, it was, the entirety of PMC was minority art is unique in this way. It provides, it's uniquely critical to minority communities' unity and self-love, etc., and their ability to talk to outside. Like, that was all of PMC. And then they say, the psychological harm doesn't make things critical. We advance a system of justice where we do things based on concrete harm. So, first of all, I already told you why that's not true. But look, we actually prosecute things based on the harms that they commit, right? Like if something is massively harmful to a lot of people, we think you ought prosecute it. We think because it's massively violative of their rights, we ought prosecute it. They say intellectual property is different than physical property, and then they say this is because, and then there's no warrant. I think that's also critical in this round, as far as they needed a warrant to prove why this was the case. So we think you ought principally prosecute this. So then what's important becomes, why do we need the criminal court to do this? So I think this is where drops come into play in a big way. So first, we tell you stuff that is, like, regardless of whether or not you win cases, is important. Well, we say they have better investigatory things. We tell you that in status quo, it's really hard for minorities to know, if their copyright has been violated, but B, have the resources, I told you, subpoena power, I tell you, like other tech things that I said, I'm pretty sure. that were real things. About how like the state has specific powers that can enable minorities to then bring civil suits, which is a unique point in our round. If all of their offense is civil suits are good and we should have more of them, this is how we get more civil suits because people know their rights are being violated, and we get better civil suits because they have better evidence and that they actually know who to sue. Okay, I think that's critically important. But then they say they also drop all of Miriam's arguments about how externalities ought to be protected through the court system and only can be protected through the court system. That's a pretty critical fact. But then they say, look, they're only going to bring cases for rich artists and only the rich can win. So, first of all, the criminal justice system has some resources. I told you about that in PMC. But also, Miriam told you about why prosecutorial incentives are going to lead towards you prosecuting the most obvious cases. I think that was something they needed to drop. But here's the weighing that loses them the round. All of my arguments about minority artists getting recognized were not unique to poor minority artists, right? I think what's critical then is even if you buy their worst case scenario, which is we only get suits on behalf of Jay-Z, that's still on balance good because we still get more recognition of minority art, which wins us the round. I think that is critical. But lastly, Miriam also told you prosecutors aren't going to bring cases they can't win. That's a little ridiculous. I think it's an unfair understanding of the prosecutorial one. But lastly, do we win cases? So two things. Broadly, this doesn't matter because I told you all the stuff about how we get better civil cases, but also about how the recognition that minorities are going to get insofar as the legitimacy of the state, or the state has unique legitimacy in bringing these cases, is going to be on balance good for them both internally in terms of recognizing, feeling like the state recognizes their art and their value, but also externally because the state has this unique legitimacy and so on and so forth. But lastly, I think it's critically important. They actually probably will win a lot of these. Why? Because a lot of them are pretty blatant. They're it's hard to prove. Guys, it's hard to prove a lot of things. But I give you examples of actual warranting of how blatant a lot of this stuff is, and therefore how easy it's going to be to prove. But again, independent of that, what we tell you is that it is humiliating for a major pop star to be brought on trial. They're not going to want to undergo these harms. That is a massive countervailing incentive against stealing minority art writ large, which means we think we get less stealing of art, but also it is why it's impactful for people not to want to undergo these reputational harms. But lastly, do we get more or less minority art? Look, this is pure offense for us. The only argument they give us is minority artists are going to use this on other minority artists. So first, we told you minority artists steal less from other minority artists. But secondly, we say this is going to be an incredibly unpopular thing to do. It seems deeply unlikely that Jay-Z is going to want to worry about the low-hanging, the guy who gets 400 views on YouTube. The last thing that I want to say that's really critical is look. There isn't a way for minority artists to get funding in status quo. The fact that they didn't solve for this means that minority art is dying on their side of the house. When we give you better civil cases, we give you a better path towards minority artists getting funding, which means we win this round pretty clearly. Proud to propose.
Here, here.